Good morning. We'll go ahead and get started here, and may have others join as we get rolling. This is Michael Brooks. For those of you who don't know me, I'm a partner in Bracewell's Government Enforcement and Investigations Group. My practice focuses on commodities trading, including compliance and enforcement, and I'm a regular MC for the Energy Compliance Network. Thank you for joining us on late notice this morning for what we are calling a flash roundtable. We had considered hosting this event next week, but realized that the topic is something many of you may be facing this week. And so we hope the discussion today will be helpful as you navigate the fluid landscape of sanctions and export controls. It's my pleasure to introduce to you this morning my partner, Seth DuCharme. Seth is a member of the Bracewell's Government Enforcement and Investigations Group as well. He draws on his experience serving as the Principal Associate Deputy Attorney General of the United States and the Acting United States Attorney for the Eastern District of New York to advise companies and individuals on cases involving cross-border regulation, cybersecurity, Foreign Corrupt Practices Act, diligence and litigation, export controls, sanctions compliance, and anti-money laundering. In addition to serving as acting U.S. Attorney for the Eastern District, Seth served as Chief of the Criminal Division and Chief of the National Security and Cybercrime Section for the Eastern District. I'm also pleased to have with us another partner, Termine, and also as a member of our Government Enforcement and Investigations Group, and leads the firm's cryptocurrency and blockchain practice. Drawing on nearly 20 years of CFTC experience, and represents and advises stakeholders in the commodities, derivatives, and cryptocurrency markets in connection with compliance and enforcement matters, litigation, and regulatory advocacy. Anne is a former chief trial attorney at the CFTC's Division of Enforcement, where she designed and led the CFTC's landmark enforcement program involving the manipulation and false reporting of LIBOR. Before that, Anne was a prosecutor in New Orleans, where she tried more than 140 cases. We are recording this discussion today. If you'd like to ask any questions, we do have a Q&A feature. If you look on your screen, it should be in the bottom right corner. There's a question mark, and you're welcome to click on that and submit questions through that feature. If you have something you want to ask but don't feel comfortable placing there, feel free also to reach out to me, those of you with my contact information, and I'll ask for you. With that brief introduction, I'm going to turn the mic over now to Seth to dive into our topic for today. Seth?
Great. Thank you very much, Michael. And it's great to be with you again, as always. Look, time is of the essence on this, Michael. I think you hit it exactly right. Sanctions was yesterday's topic, and sanctions is going to be tomorrow's topic. And that's largely because this is one of the few areas in which the United States government can actually move quite quickly. And that's a function of the fact that the sanctions regime flows largely from executive orders, which then just trickle down through the executive agencies, enforcement agencies, and regulators, essentially with the force of law under the International Emergency Economic Powers Act and some of the other export controls. So it's a rapidly changing environment in terms of risk of all kind. I think the way to prioritize it right now for corporate entities trying to assess what they should be doing differently today as opposed to a month ago is that there are essentially three types of risk we need to focus on contemporaneously. And those are reputational risk, commercial risk, and legal risk. I'm going to focus primarily on legal risk, but that is not necessarily the most consequential type of risk in the environment that we're in right now. So I'd be remiss to not point out that the market is largely trying to self-correct and self-direct in response to essentially the world's view of largely the world's view of Russia's activity in the Ukraine right now. So we have seen a number of companies, even before certain sanctions were implemented or before directives were coming out from the administration, try to take proactive steps to limit reputational risk that would be associated with the perception that they were in any way bolstering the efforts of the Russians in Ukraine directly or indirectly. Anecdotally, I read recently that there's a professor at an Ivy League university in the Northeast who's created a naughty list of who's still doing business with Russia in some form, and this has had a significant effect on the market and and corporations' attempt to meet expectations of customers, consumers, and shareholders. So it's not simply enough to say, well, I'm technically in compliance with every aspect of the law. If the reputational injury that you suffer causes you, substantial prejudice or losses, corporations, of course, are not in the business of simply complying with U.S. government regulations. They're in the business of providing a service or a product and creating value for your customers and for your employees. So we can't lose sight of the fundamental purposes behind some of these strategies. Continue cultures of integrity within your corporations. Continue to try to build value for your shareholders, your customers, but be mindful that the overall environment has become more complicated than it was previously. In terms of commercial transactions, um, you are the experts there. I am principally a defense attorney and a compliance lawyer now, but what I will warn you is that all indicators suggest that Russia is feeling uh, uh, the pressure of the tightening chain around it in its financial markets, and it is even per FinCEN's recent alert is going to be expected to increasingly rely on shell companies, third parties, fourth parties to try to disguise the origin of a transaction, and it's going to be doing it at likely a pretty fast tempo. So that means you have to be wary of two things: new customers and counterparties, and really applying a know your customer, know your counterparty type of diligence to a greater degree, frankly, than you probably would have had to do a few months ago. That can be especially challenging, in an increasingly digital world where the face of a counterparty you often see as a representation on the internet, and we have learned to be distrustful of some of those representations. So you have to know your customer, you have to know your counterparty, you have to be wary of anything that looks like it needs to move quickly, because you may end up having to leave money on the table in a commercial transaction. And we know that a number of corporations have already walked away from deals, potentially leaving or actually leaving money on the table because they did not want to be part of an actual or even perceived effort to aid the government of Russia or an oligarch or entity associated with the government of Russia that would essentially serve as a surrogate for Russia's activities. So, in terms of commercial transactions, unfortunately, it's a time to be a little bit more conservative with the deals that you're entering into and the parties that you're dealing with until you have real confidence that your traditional anti-money laundering, compliance, KYC, diligence programs are matching the tempo and the risk level of the current environment that we're in. So, what a bottom line up front here a little bit because how we got here is probably less interesting to people than what we need to be doing right now. Um, so there's the entity and the transaction, and then there's also the sanctions regime, and it's changing almost daily. So how do you keep up with those changing regulations so that you can make responsible decisions? The Russian sanctions efforts have been truly a whole of government approach from the U.S. government's point of view, from the president's remarks at the State of the Union. I don't want to say trickling down, but flooding down, I think is more accurate, into all of the U.S. government agencies and components that have responsibility to enforce sanctions. And I think it might be useful for you to know, if you don't already, that the reason that the sanctions regime can move so quickly in the United States is because it is primarily a national security and foreign policy directive. And the International Emergency Economic Powers Act, which is what can create criminal liability for sanctions violations, it's kind of an unusual statute that incorporates executive orders and the Code of Federal Regulations into it, essentially to allow the United States government to criminalize behavior very quickly. That's not normally how we create federal liability, criminal liability in this country. So it can move faster, and it means you have to pay attention not just to one message, unfortunately, but to multiple schemes. They're related, but they're distinct. And I'll give you an example in what I would consider to be your order of general importance. You've been hearing a lot from Treasury, and that makes a lot of sense, right? Because the Treasury Department watches money and creates policy and regulation around the movement of money. Within the Treasury Department, you have the Office of Foreign Asset Controls, OFAC, and you have FinCEN, which are two entities to watch. Helpfully, OFAC and FinCEN are pretty good at public messaging as compared to other government agencies, which can often seem like a black box. So I don't want to talk myself out of a job here as a sanctions lawyer, but I will tell you a lot of the questions, really particular questions that you might be inclined, to ask a lawyer, and trust me, I'm happy to take those. You can find the answers to on the OFAC website. It's actually really pretty good, and you can even set up alerts so that OFAC will notify you of developments, and that's a good idea right now because they've been coming out fast and furious. There's a section related to the Russia-Ukraine sanctions. There is a frequently asked questions section on the OFAC page, which is frequently updated. And to be frank, if we were going to match a tempo where our clients and our lawyers and our consultants were all on the same page at the same time, a good place for us all to be looking right now would be at OFAC's updates and responses to FAQs as they come. There are also provisions there for how licenses may be obtained, where licenses are available, and perhaps most important to you, if you're in the middle of a transaction, there are key dates which OFAC has set by which certain transactions that fall within a new sanction must be wound down. So, for example, the one that relates to the sanctions on the import of Russian oil, there's a wind down period that expires April 22nd. That's not that far away. So these are the kinds of things that we collectively, as the lawyers and operators and entrepreneurs and consultants in this area, really need to be watching at the same time so we can move forward in lockstep. Um, Another Treasury agency, which is worth watching and which I'll paraphrase for you rather than just sending you to a website, is FinCEN. FinCEN has been issuing some helpful guidance recently and timely about red flags to look for in transactions. And not only is it helpful in the sense of FinCEN saying, hey, you should now be looking at kind of middle market money movers like casinos and mortgage brokers and insurance brokers and others where value and assets can be moved. You should be taking a closer look at these types of entities because they are the types of entities that Russians or those aligned with the Russians may be availing themselves of to try to fly under the radar of, let's say, some of the bigger, fancier banks that have more robust compliance programs. So FinCEN, on the one hand, is saying, hey, these are some things to look for. It's a double-edged sword, though, because it's also essentially putting you on notice as to what FinCEN and the Treasury Department is going to consider a failure to exercise due diligence and an appropriate standard of care in a compliance program because they told you what they are expecting you to do. So if you weren't applying that level of vigilance to the transactions in which you're engaged or in which a counterparty or related entity could be engaged in, FinCEN is essentially saying, shame on you. We told you. In terms of cryptocurrencies, there's been a fair amount of discussion about whether or not cryptocurrency can be used to evade sanctions. Potentially, yes, in that crypto is, of course, authentic on its face and trackable to some degree through blockchain, but the end users of crypto are often anonymous by design. And the sanctions regime is almost always, with some exceptions I'll talk about attribution. In other words, do you know who you're dealing with, and are they on a very specific list of individuals, entities, or countries with whom you cannot do business? So to the extent cryptocurrency makes it more difficult to attribute true identity to a counterparty, it could potentially be used to evade sanctions. That said, FinCEN, in the same memo where it warned about crypto risk, said we're not really seeing it right now, but it's possible, so let's pay attention. We have another consultant, trusted consultant with whom we often work, who noted, as I think others have, that cryptocurrency is not really going to solve all of the government of Russia's problems now in any event, because there's simply not enough of it in the market for it to replace more traditional types of specie or assets. So you may see, some of the Russian oligarchs has been highly publicized, have been the targets of sanctions, and some of the entities in which they own majority interest. It's not impossible that you see crypto used to some degree, and so therefore you should be vigilant to it. But I don't think, at least in the near term, it's going to be material to the overall effect of the sanctions, on the markets. So reputational risk, commercial risk, legal risk, upping your standards of vigilance and diligence, and diving down a little deeper in your KYC practices. And sometimes that may mean using consultants to help you with that due diligence, particularly if it's a largely digitized transaction with a party with whom you've not dealt previously. I would say you have to be especially careful. So that's the sanctions regime as it relates to money. I would be remiss if I did not mention that there are related and complementary controls in place right now that could affect your business or activities either directly or indirectly. So I said Treasury focuses on how money moves. The Commerce Department focuses on how technology moves. And there is a commerce control list, and it is often overlapping with the State Department's munitions list, at least in concept, in that both the State Department and the Commerce Department have the mission of denying adversaries and potential adversaries of the United States the material they need to create a war machine, to be blunt. So that could be anything as innocuous as high-grade carbon fiber, which has multiple applications, for example, in the construction of lightweight bicycle frames or golf clubs in some instance. But commerce will restrict the export of carbon fiber to places that have nuclear enrichment programs underway, because you can also use it in centrifuges. So some of these items that you might think on their face are innocuous, and carbon fiber is the one most frequently invoked. In fact, the head of enforcement for commerce at the ABA conference just last week used a very similar example to say commerce is going to be advancing and energizing its efforts to police U.S. controls of the movement of technologies internationally. And that can be a little complicated, particularly if you're dealing with third parties in countries where you may be allowed to be part of a transaction where that technology is going, but there may be reason to know with greater diligence that that's really just a hop point to another end state. So you have to pay attention to commerce. I take them at their word when they say you're going to see increased enforcement in this area. I think you're going to see increasing regulation coming from commerce as part of the effort to starve the Russian war machine. So we did a case in EDNY a few years ago about microcircuits going to Russia to be used in the forward-looking radar nose cones of Russian fighter planes. And the way the Russians were getting them is they had a US-based company procuring microcircuits purportedly to be used in traffic signals, traffic lights, and then they diverted them to Russia. So to the extent that you're at all involved in the movement of control of technologies, you really want to pay attention to commerce, and to the commerce control list, and to think about that. State Department, has a somewhat blunter approach to export controls in that the munitions list says has a list of items, material of war, not just guns and ammo. Um, it includes things like gyroscopes and night vision and other technologies that have application in the defense industry. And they simply say you can't export it anywhere without a license from the State Department. And I flagged that for you, not necessarily because you're in the business of exporting munitions, but I have seen a number of grassroots efforts spring up, including around me in the New York City area, to support the Ukrainians by shipping them weapons, to be frank, and things that could be useful to them, like night vision and other equipment. It's not to say it can't be done, but if you do it without a license from the State Department, it's a federal crime. And if you agree to do it or aid and abet in the doing of it, you can have liability. So there will, I think, hopefully be a fair amount of discretion exercised by the U.S. government here in not looking to punish people who are in good faith trying to support Ukrainians or our allies. But it would be a surprising way to get in trouble, I think, for a lot of folks if they thought they were doing the right thing and supplying the Ukrainians and then found out that they were violating State Department export controls or endeavoring to. So something I've not heard from a lot of other sources, but certainly something to pay attention to. Um, Cybersecurity is another big part of our practice. This will sound very much like beating a drum. We all know we have to have good cybersecurity practices that are at or above industry standard. Uh, I think something has, though, materially changed with the situation in Russia, in that I used to be able to say with some level of comfort to mid-sized corporations that were not the holders of great financial resources or highly valuable intellectual property, um, you are unlikely to be targeted by a tier one foreign state military unit. You're most likely going to be targeted by a criminal ransomware actor. And to some degree, you can factor that into the cost of your doing business and figure out what your pain tolerance is going to be and what your conscience is going to tell you about paying a ransom to criminals in order to keep your operations going. And that's an unpleasant conversation, but it's also not really an existential threat. And I think a lot of corporations now have thought about how they would handle what I would consider to be the run-of-the-mill criminal ransomware attack and how much pain they're willing to sustain to not pay it and keep operations running. Now, unfortunately, we are all potential targets of a tier one foreign government, state actor, military intelligence unit type of attack, which cannot necessarily be cured with a distasteful payment of cryptocurrency, but may actually be designed to disrupt and destroy corporations which previously had no incentive to invest sufficient resources to try to withstand or survive attack by a foreign intelligence service. I think you now have to assess again what your risk profile is with respect to the government of Russia, because they are vindictive in the first instance, and they have an incentive to just create pain and confusion just below a threshold of some kind of proportional response. And the rules of engagement in cyber activity between our governments are not clearly defined. They're evolving on a daily basis. And so I mean to suggest to you that it's I don't want to be an alarmist, I really don't, but it has to now be within your thinking that because of what you're doing transactionally, in your corporate activity. In other words, I'm leaving Russia. I am dropping a counterparty. I am refusing to enter into a deal because I perceive that could create risk for me and it could help the Russian government. Um, Depending on the level of pain that that causes the Russian government, they may want to hurt you back. So you could be a direct target of Russian government action, depending on how mad you make them. And secondly, if you think that, the Russians are certainly feeling the effects of our U.S. sanctions, and Putin has not been at all shy about saying, how seriously he takes the sanctions, and he's going, if for no other reason than pride, wanted to continue his efforts to create confusion, distrust, and some level of pain and disruption in the United States. And so I could see a Russian government effort tasked at cyber activity such as disruption to supply chain, not necessarily critical infrastructure. And I'm going to use an example here, which I take seriously, and I don't mean it to be glib. You can all remember when COVID happened and there was the perception of supply chain interruption, some accurate or not accurate, and people freaked out about toilet paper, right? The lack of toilet paper does not create an existential threat to any individual, corporation, or country. But it freaks people out. The notion that they can't even get a basic, what most would consider a necessity, what some would consider a luxury, but that they can't get this thing that they've always taken for granted. And so while the hard targets in the U.S. economy and infrastructure have always been our financial institution, our national security infrastructure, and our intellectual property, the target set now, I think, is logically expanded to include anything that's manufactured or moved in domestic commerce, which if the American people were denied, would make that upset and could arguably turn public opinion against the strategies of the United States government. In other words, I support our efforts in Ukraine up to the point that I can no longer get toilet paper. And I'm not trying to be funny, but that's the way these kind of psychological ops are run by foreign governments against us. More importantly, it doesn't even have to be a successful disruption. So let's say you made toilet paper or toothpaste or dog food or some other thing that we don't necessarily think of as being essential to our national security, and you were the target of a disruption of services attack on your website so that your customers could no longer see where their orders were, or there was just great confusion created temporarily in how you communicated with customers, but no actual effect on your ability to manufacture or distribute that product in the stream of commerce. What the Russians would likely do is then add a layer of disinformation on top of the effort and falsely report through the social media platforms that are available to them through surrogates. There is no more toothpaste on the shelves of supermarkets in America to try to create a panic. You all saw this happen to some degree with the pipeline ransomware attack in the spring and people lining up for gas at gas stations which were not supplied by the pipeline. I use this as an example again, not to create panic or alarm, but to say in how we're thinking about where our risk lies and how we can mitigate it and how to get ahead of the tempo of potential threats that come in and ultimately feel more secure and confident about the way we do business and our resilience and ability to survive and remain a going concern, even in the face of political unrest, reputational risk, commercial risk, taking a more conservative approach in certain types of transactions, putting in the energy to monitor the developments in the sanctions regime, looking to see what the EU is doing, the UK, Canada, some of our other foreign partners, to make sure that we're roughly in lockstep with our strategies. We want our strategies to be as sound in principle as possible so that we don't have to adjust on a daily basis, that we can monitor but have confidence that our strategies are sufficient to or ahead of the curve. And I think that involves everything, unfortunately, from know your customer, up your vigilance, dig deep on on your diligence, monitor OFAC, monitor FinCEN, pay attention to the Justice Department, which is the prosecution arm for IEPA, and they are trumpeting their increased enforcement efforts. Double down on your cybersecurity and intellectual property protective efforts. take a fresh look at your critical incident response plan, sober up to the fact that you may not have been a reasonable target for a government level cyber event a few months ago, but you could be now. Um, I would say it's gonna really benefit you to think about these issues together, how they relate to one another together. Think about it hard, give it the attention now, develop best practices for going forward, and then get back to the business that you do. What I'm most worried about is a continuing state of anxiety in the markets and in the corporations that they're going to feel we're all going to feel very reactive. I can't operate normally because I'm always worried about what's going to happen tomorrow. You can come up with strategies and principles that will allow you to get ahead of that. So, um, I'm going to leave it at that as an overview. I know there's an awful lot to unpack there. I would caution you not to take this presentation as true legal advice upon which you should rely to make a decision on a transaction tomorrow. It is specific enough, these sanctions, that you've really got to look at all the facts of your deal. But hopefully, this framework, gives you at least a way to issue spot, and depending on the nature of the transaction or your particular exposure, a way to start mitigating and then ultimately getting ahead of the threat. So, Ann, I don't know if you have any thoughts to add to that, or Michael, if you have any questions or comments, or if anything's come up during the course of our discussion.
One question did come up, and it has to do with the physical delivery of energy products like oil, given the new sanctions. And we don't want to put you on the spot from this perspective. And Michael, I think you were going to just generally address the trading. But I'm going to throw one out while you do that. I'm going to throw a question out there for Seth to think about in the meantime. Given that the energy sanctions have been very new and still evolving, particularly the banning of Russian oil, what do you do when you receive a shipment through a transaction that may have Russian, or it may have originated from Russia, but that may not necessarily be your counterparty, but where the oil came from? So that's one question. But in the meantime, let's let Michael address the markets generally.
Yeah, and there was a really good question about how Platts and how the exchanges are handling this when it comes to physical delivery, and I don't know. I actually am gonna, when we finish here, look into that. I haven't seen any exchange notices about how they're handling it, but on with the exchange you have your counterparty isn't really your counterparty until you go to delivery. So I think in terms of trading on an exchange, I'm not terribly concerned there. But if you take a contract from an exchange to delivery, I don't know the answer to that. I'm going to look for it today. But with Platts, I would think this would be handled just as it is, as it has been with Iranian cargoes and other limitations, where your bid or offer would have in it the limitations that you're imposing on the counterparty or the origin. I don't know if Platts has taken any steps to, sometimes when you put too restrictive of limitations on something, you can be put in a box and not counted in the survey anymore. Not aware of that happening with the Russian sanctions, but wouldn't be at this point. But I think that with Platts, I think I would think we would follow the same practice we've followed with other limitations we've had in global sanctions and U.S. sanctions. With the exchanges, I'm not sure if you're taking an exchange product to physical delivery. I would expect a U.S. exchange to have had the same counterparty, know your customer limitations that would protect us there. But I haven't looked closely to see yet what the exchanges are doing there. I don't know, Seth, if you or Ann, if either of you have more thoughts on that.
No, my only thought is that I think it's a very useful analogy to look at how we've dealt with Iranian shipment in the past for general guidance. I think that makes a lot of sense, Michael, and I think that the defense essentially to any sanctions regulation the best defense is going to be truly what you said, which is imposing conditions in good faith on any direct or indirect, to the extent you can do it, participants in the chain. And as long as you make clear your position, you act in good faith. And while there is strict liability, at least on the regulatory side for this, what else can you do, right? What else can you do but that in trying to comply?
I think this also goes back, Seth, to what you're talking about in terms of reputational risk, isn't it? And we've seen reports of certain companies refusing to accept oil because they're not clear of the origins of it. Clearly, it sounds like you're saying that we don't necessarily need to go that far, but the reputational risk might take companies to that step.
I think that's right. I mean, I printed out because I thought it would be timely the particular the most recent OFAC guidance of March 8th that talks about the ban on the import of crude oil, petroleum fuels, et cetera, that are Russian origin, and the existence of a general license that provides a wind down period through April 22nd. But in terms of the reputational or the commercial risk, you've got to ask yourself, even to the extent I can read this as OFAC saying, well, as long as you're out of the market by the end of April, it should be fine. Do you really want to be today or April something, last person standing um, reputationally, where everybody else has dropped and shaken their fist in solidarity with the Ukrainians against the Russians? You want to be the one person left still doing business. So hard call to make. I guess it's all risk reward, depending on the nature of that transaction and how far you want to push it. But I think you're 100% right. What are going to be the long-term consequences for those who really try to thread the needle? With the sanctions, to get the deal done, to take the winnings off the table today, what they might be leaving behind later.
That certainly makes perfect sense to me. Michael, I don't think we have any additional questions. Is there anything that you wanted to add?
That's right. If anyone has more questions, please put them in the Q&A. Otherwise, I'll leave it to you guys to close out. Any further thoughts?
No, not at all. I'll just say our sanctions team at Bracewell is monitoring these developments on a daily basis. We're pushing out, client alerts occasionally, but I have to say the airwaves are flooded with sanctions talk these days. So you can expect to hear more like this from us. But really, if you have any particular questions relating to the facts of your transaction or situation, please don't hesitate to give us a call. Chances are we've already had to look at a similar issue for someone else, and we're here for you.
That sounds good. So basically, the takeaway is if you have a question, ask it and ask it quickly because the sanctions are moving that fast.
Yeah, and I do have to give credit to the Treasury Department that the OFAC page is not as intimidating as some other government pages, and so it's not a bad place to start for a clear answer. But we're always here for you for the fine points.
We did get one additional question about Russian products already in the tanks, but it sounds like because there is a deadline into April, there is some allowance for transactions to complete themselves within that time frame. The only question is what happens after that April 20 something deadline, right?
That's right. And OFAC, OFAC encourages consultation, in fact requires it in many instances, when there's a question that could implicate the sanctions. So you can take them at their word on the page, but also it would probably be a good idea to engage with them directly with respect to a particular transaction to get comfort that you are truly in compliance.
So even though it seems like it's probably okay to complete the transaction and receive delivery between now and April, if you have a question, call OFAC. And certainly once you get towards that deadline, it's a really good idea to give them a call.
Yeah, and I would say just as a responsible attorney, you probably want to have a lawyer call OFAC because you are talking directly, to the government.
That's
I know
right.
there are a lot of sophisticated parties, in this audience, and I don't mean to discourage you or be condescending, but what you tell OFAC can have consequences, for you later. So at least have a consultation before you engage with them.
That's no different than talking to my old agency at the CFTC. Just be very careful what you say because it could come back to you.
All right, so thanks again. It was great to see you all again, and look forward to continuing the conversation as this whole landscape evolves. Stay well.